All right, I'm seeing the intake of participants slow down, so I think we are probably good to go. I'm reading at well, 1:32, so we're good. We're on time. So thank everyone for joining this month of our ongoing webinar series. We are going to be talking about bankruptcy code and how it impacts tenant landlord law here in Minnesota. We're being joined by Drew Glasnovich. He is an associate at Stinson. He does bankruptcy law as his bread and butter on a day-to-day basis. So, but in his spare time, he also works a lot of pro bono hours with evictions and helping out tenants in eviction court. So he is the perfect person to be talking about this today. So I greatly appreciate you joining us and helping unmystify some of the overtures of where landlord tenant law and bankruptcy code interact, because it's a little complicated.
That's right. Thank you, Rachel.
Absolutely. A couple of housekeeping things real quick from my end. So Homeline, in case you are new to these webinars, we are a statewide nonprofit organization. We offer free legal educational advocacy services for Minnesota renters across the whole state. We've been around since 1992, so a little over 30 years at this point. Our hotline is free. We offer it in 4 languages plus email. So we offer Spanish, Hmong, Somali, and English. And again, we have an email option as well for folks. So that's all of our information there on the screen if you have questions or want to refer renters to us. Often the most common questions we get here, we will be applying for 1.5 standard CLE credits. We will do that shortly after this is done. The session is being recorded and it is going to be available on our website in a few days. So that is homelinemn.org. And if you have questions, and we greatly encourage questions, I know I probably will have several questions. Please use the Q&A function that's at the bottom of your screen. We will go ahead and I'll ask those either throughout, or we'll also have time at the end for questions. So please ask away. You know, again, this is kind of a complicated topic. So if you've got questions, feel free to ask. Or if you don't have questions about bankruptcy, but do have questions about like tenant landlord law in general, I'm here to also help as well to answer those. We've been doing these webinars since, gosh, March of 2020, technically. And so it's a space for folks to be able to ask questions and get some insights into what has been an ever-changing world of tenant landlord law. So happy to help out, happy to answer questions as we can. We do have 90 minutes today to get started. So without further ado, I'm going to stop sharing my screen and I'm going to turn it over to Drew.
Rachel, thank you so much. I appreciate that introduction. I will pull up my slideshow. All right. So like Rachel said, my name's Drew. I work in the Bankruptcy and Creditors' Rights Division, doing mostly commercial bankruptcies. So most of my clients are either companies who have declared bankruptcy or people that those other companies owe money to. But my practice intersects a lot with landlord tenant law. And Rachel and I thought this would be a great opportunity to kind of explore that. There's a lot of nuance that goes into what happens in a landlord-tenant relationship when somebody files for bankruptcy. And so that's the basics of what we'll talk about today. I'm going to cover a few topics, and probably most interesting to everyone on this presentation, we'll do a little bankruptcy 101. There's a lot of terms that I want to help you guys understand. And then we'll talk about the automatic stay, which is one of the most important pieces of bankruptcy. It means that the person who filed for bankruptcy basically can't be sued during the bankruptcy process, can't be collected against. So we'll talk about what that looks like in a landlord-tenant relationship. And there's some really important things we need to go over regarding exceptions to that. regarding a tenant especially. And then we'll spend the bulk of the time today talking about leases in bankruptcy. And there's a lot of important things the bankruptcy code does to modify leasing arrangements between a landlord and a tenant. And we'll go through that a little bit in detail today. And along those lines, we'll talk about specific protections that tenants get if they file for bankruptcy. And we'll also talk about special protections landlords get if they file for bankruptcy. And then we'll also touch on security deposits and what happens to a security deposit in bankruptcy. It's a kind of a unique question. And Rachel may need to help me out a little bit in talking about what happens in Minnesota. I think there's some unanswered questions there, and we'll talk about that. So, bankruptcy. I like to conceptualize bankruptcy like this picture. That's what it's like in my head, at least. So what this picture is meant to represent is the seagulls are all the creditors. And the person who files for bankruptcy is the poor individual who dropped their French fries. So, the individual, something's happened in their life where they can't necessarily pay all their debt obligations when they become due, and they need some help. And so, they've dropped their French fries, and here come all their creditors, who are the seagulls, and they're after those French fries. And what the bankruptcy code does is pause everything. It doesn't let the fastest, fattest seagull eat all the French fries, leaving the other ones for nothing and leaving the person who dropped them without anything. That's not what the bankruptcy code is about. The bankruptcy code stops everything, gives the person who filed for bankruptcy a little bit of space to figure out a path forward, and provides them some protections and some abilities that you wouldn't have under normal state law to fix the problem. And then it also divides out those French fries in a fair manner. It provides a way to give everybody a little bit of something, and also gives the person who dropped them, the debtor, the person who doesn't have the money, a little bit to keep too. And so it's a way to kind of fairly distribute assets in a time when somebody's kind of fallen on hard times. The bankruptcy code has lots of different chapters. And as bankruptcy professionals, we love to talk about our chapters. And I'll kind of describe what they are. You'll notice we skip chapters. I don't know why. There's some really good historic reasons why, but it doesn't make any sense. So if you're wondering what chapter 8 is, I don't know. So you have a chapter 7 case. That's what we primarily call a liquidation case. So if a company files a chapter 7 bankruptcy, that means the company is going to go away. It's not going to be around anymore. It's going to close its doors, and it's going to distribute its assets out basically evenly to its creditors. An individual can also file for chapter 7. Obviously, the individual is not going to go away. And so it's a little bit different. But the idea in an individual chapter 7 is that there's not enough assets. That person doesn't have enough assets to pay their creditors. And they don't have enough assets overall for it to be worth it to try to pay over time or provide some other relief. So what happens is that individual has what's called exempt assets. So that's like their house, their clothes, their car, that don't get divided among creditors. And then there's some assets that aren't exempt, right? So if you have a vacation home, right, that would not be exempt, and you'd have to sell that and pay whatever the sales price is to pay off your creditors. And that's kind of the basics of a chapter 7. It's really simple. Then you have a Chapter 13. And so Chapter 13 is where an individual files for bankruptcy. It doesn't have anything to do with corporations. And they have the ability to pay their creditors, but it may take some time. They have enough assets that it could be worth it to pay their creditors over time, and they can keep those assets if they pay enough to their creditors. And usually in a Chapter 13, it's a 3-year or 5-year payment over time plan. And we use the term plan a lot as a way to indicate, excuse me, kind of like a new contract. A plan is kind of like a new contract between the person filing bankruptcy and all of their creditors. And so in Chapter 13, the person filing bankruptcy gets to propose a plan, gets to propose a way to pay everyone over 3 to 5 years. Excuse me again. And then gets to move on. And then that's the end of it. And they don't necessarily have to pay everybody in full. That's the other nice thing about bankruptcy, is that it's a pay what you can kind of system. It doesn't mean every creditor gets paid 100 cents of what they're owed, but it provides structures to make sure they're getting paid as much as possible, while also giving that person who filed for bankruptcy the ability to move on with their life. And then the last kind of bankruptcy that we should talk about is a Chapter 11. Chapter 11 can be a person, an individual, or a corporation. And it's really meant to reorganize. And what I mean by that is the company will most likely still exist after the Chapter 11. And for individuals, individuals file Chapter 11 because they have a lot of assets. Usually very wealthy individuals will have to file a Chapter 11. And the difference between a Chapter 11 and a Chapter 13 is in a Chapter 11, to get out of bankruptcy, you have to pay the equivalent of what all your assets are worth at the beginning of the bankruptcy case. So if a company goes into bankruptcy and they have $5 million worth of assets, they don't have to sell all those assets, but they have to provide a way over 3 or 5 or 10 years to pay $5 million to their creditors. And the same thing happens in a Chapter 11 for a person. If a person has $5 million worth of assets, they have to figure out a way to pay their creditors $5 million over the next 3 or 5 or 10 years. And so those are kind of the different kinds of bankruptcies. There's a few more, but we won't worry about that unless someone has specific questions. Most commonly for individuals, and especially individuals who would most relevant to this presentation today, would be a Chapter 7 case or a Chapter 13 case. And that's probably the most common kind of bankruptcy that you would see. There's a couple terms that I may have used already, and I apologize if I used them and didn't define them. But the first term that you'll see, and we need to know this because it shows up in the bankruptcy code a lot, is the term debtor. And that's just the person who filed for bankruptcy and who owes other people money. That person's a debtor. And then the other term is creditor. And that person is the person who is owed the money. So a landlord or a bank or somebody else, those are typical kinds of creditors. So that's the basics of bankruptcy. The whole purpose of bankruptcy, again, is to provide a way to get a fresh start, and not to let one creditor who, is the first person to the courthouse to get all the money and leave everybody else high and dry. It's a way to make everything fair for all the parties involved. So the first topic that's important for us to understand today is something called the automatic stay. And this is a pretty legal term, and I'll try to break it down in a way that kind of is intuitive for everybody. So like I said before with the analogy on the seagulls, right? Bankruptcy wants to keep those seagulls from getting those French fries. And the automatic stay is the way to keep the seagulls away from the French fries. As soon as somebody files for bankruptcy, it's automatic. It happens by virtue of you pushing the submit button with the court. This automatic stay exists and it applies to everyone in the whole United States. The automatic stay prevents the person who filed for bankruptcy, the debtor, from being sued for anything that they did or anything that they owed prior to filing for bankruptcy. So no lawsuits, no attempts to collect money. So no demand letters, no phone calls, no repossessions, nothing. And then no attempts to collect property. No, like I said, repossessions, no setting off at a bank account, none of that. Everything has to be stopped and channeled into the bankruptcy court. So the bankruptcy court becomes the sole place that any of that stuff can be decided, with a few exceptions. And so it's very powerful. It's a federal stay. So bankruptcy law is federal law. And because of the supremacy clause in our US Constitution, that means that federal law overrules all state laws. And bankruptcy is one of the few federal laws that also overrules most other federal laws. It's very powerful. And so the IRS can't come collect after you. The Minnesota Department of Revenue can't come collect after you. None of that is permitted during the bankruptcy. And the automatic stay has teeth. It's enforceable, and it's enforceable at the bottom by just invalidating. So if somebody sues you while you've filed for bankruptcy, that lawsuit is void. It can be dismissed automatically because it was filed in violation of the automatic stay. And if somebody violates the stay willfully, there are damages that you can get as well. And so it's pretty powerful. It's pretty scary. Whenever I have a client who got notice of a bankruptcy case, we spend a lot of time describing all the things that client cannot do now to collect money. And it's a very powerful protection. Now, all of that said, there are a few ways that you can get past the automatic stay. The most common way to do that is what's called filing for relief from stay, or sometimes we call it lift stay. All that really means is you go to the bankruptcy court and you ask for the automatic stay to not apply because you have a really good reason. And normally the bankruptcy court will say no. It's a pretty big hurdle to overcome if you want to get past the automatic stay. And again, the reason for that is because the bankruptcy process is meant to make things fair, and it's not supposed to let one creditor get all of the money and leave everybody else high and dry. So you've got to have a really good reason for wanting to get relief from the automatic stay. And there are two really notable exceptions when it comes to landlord-tenant to the automatic stay. And the first one comes when, before the bankruptcy was filed, the landlord filed an eviction and got, in Minnesota, it would be a writ of recovery issued. So they have the writ of recovery in hand, and they're about to go serve it, or they've already served it and they're just waiting for the sheriff to come and change the locks and kick the person out. There's an exception in that limited circumstance where the automatic stay does not apply. And so what the bankruptcy code says is, if you have a judgment for eviction or judgment for possession, there is no automatic stay, and you can move forward evicting that person, notwithstanding the fact that they've already filed for bankruptcy. And so that's something really important to remember, is that if the writ is issued, this applies. If the eviction's filed, it does not apply. If you're waiting for a decision for the writ, it does not, this exception does not apply, and the automatic stay would still protect you. It's only when that writ's issued, right? When the landlord obtains a judgment for possession. That's the key right there. However, and I actually learned this in preparing for this presentation today, the bankruptcy code gives the debtor, the tenant, a way to get around this. And it's not great. It's kind of a difficult hurdle to overcome, but there is a way. And the process is as follows. So assuming that the tenant could redeem, even though the writ of recovery was issued, assuming that the tenant would be allowed to redeem under Minnesota law, let's say, and the tenant deposits with the bankruptcy court the next months of rent, and the tenant makes basically a disclosure when they file for bankruptcy that they're going to do this, right? That they're going to exercise this process, and they pay all the past due rent in 30 days, within a month. Then they the automatic stay still applies, and they can't be evicted once they file for bankruptcy. Now that's complicated, right? And so we can go through and break that down again, because it's a complicated process. So the tenant is going to be evicted. There's a writ of recovery in hand. The tenant files for bankruptcy. Normally that would not stop the eviction, but the tenant can, when they file, declare that they're going to use this exception, deposit a month's worth of rent with the bankruptcy court, and cure all the monetary defaults that were at issue in the eviction within a month after filing for bankruptcy. If all of that happens, then they can stay in their residence, and the automatic stay will still protect them.
I have a question that I just want to prop up, and to give you a second to like breathe, take some water. So I know there's often a question of like how long that takes then. So like tenants have to deposit just 1 month's rent into the bankruptcy court, and then they have to pay all of the arrears within 30 days of that deposit, of them filing, or is it of them getting a bankruptcy, like basically having the case all wrapped up with a bow on it?
Yeah, that's a great question. So it's 30 days from when they file for bankruptcy. They've got to be able to pay all of the past due rent.
Okay, perfect. Thank you for clarifying that.
And so this is not very tenant friendly. This is not the greatest protection, but it is something, and it's something to keep in mind when strategizing about whether bankruptcy is going to be a good option for a tenant. And in my mind, at least, looking at this, the real critical factor is whether or not you get that writ of recovery. And filing for bankruptcy before that writ is issued is way more powerful than waiting till after the writ is issued, because you've got an uphill battle then. The other exception, and this is probably less used, is if the eviction was filed because of some kind of safety issue, or because of drug possession. And there's a special part of the bankruptcy code that makes the automatic stay not apply if either of those two things happen. But again, there is a process a tenant can use to overcome that. So the way this kind of works out is the tenant files for bankruptcy. The landlord wants to proceed with their eviction because it was for a safety risk. The tenant is a safety risk to the property. The landlord has to file an affidavit with the court stating this, right? Providing the complaint they filed for the eviction and giving all the facts that would support the safety risk. And then the tenant can challenge that. They can file their own affidavit saying, no, this doesn't have anything to do with safety. Here's what's really going on. And the bankruptcy court will hold a hearing and decide whether or not the automatic stay applies or not. And so there's some procedural protection still that the tenant has if the landlord's pursuing a safety or a drug possession based eviction.
I got another question on that.
Yeah,
Sorry, Drew.
go ahead. Yeah.
So for it says about all of those exceptions are to continue an eviction. What happens if the landlord tries to file an eviction? Is that what this slide is about?
Yeah, no,
Essentially?
that's a really good question, and it's a good segue into this slide, actually. So if the tenant has filed for bankruptcy, and then for some reason the landlord was delayed in getting around to evicting, the automatic stay prevents them from filing an eviction. They cannot file an eviction. No civil actions.
No, so just full stop, even if it's a safety or drug related concern.
Correct. And then this slide will talk about but.
But
yep. So that's perfect. So I had mentioned earlier that the bankruptcy code channels all of the disputes into the bankruptcy court. It creates a one-stop shop for all kinds of disputes. And normally you do that so that you don't get kind of disjointed opinions or each court kind of dealing with its the situation before it in its own way. You get one judge who's kind of in charge of everything. They see the big picture and they can kind of help make everything as fair as possible. It's all about the fairness piece of bankruptcy. And so Rachel's point and scenario is a really great one. So let's say a tenant files for bankruptcy, and the landlord in the middle of the bankruptcy process. Bankruptcies can take a month, they can take 3 years. It just kind of really depends. So at some point during the bankruptcy, the tenant becomes a safety risk. They've done something that makes them staying at the residence dangerous. So the automatic stay prevents the landlord from filing an eviction. So they have two options. One, they can file a lawsuit in the bankruptcy court to do the eviction. And that's permitted because the bankruptcy court's overseeing everything and they can kind of moderate whether it's appropriate or not to proceed with that lawsuit. Or the landlord can seek relief from the automatic stay. And I think that a safety risk would probably be one of those exceptions that we talked about for why the landlord could get relief from the automatic stay. And I think that's probably the route a landlord would go to proceed with the eviction. And this slide talks about why. So the summary of the quote on this page is that federal courts, and especially federal bankruptcy courts, don't like dealing with specialized state law. So evictions is absolutely a specialized state law. And though state courts do not, or sorry, federal courts do not like dealing with evictions at all. And so what would probably happen is that the landlord would go to the bankruptcy court. They would say, bankruptcy court, there's a health and safety issue. Please give me relief so I can go file an eviction action in state court. And the bankruptcy court would say, yep, that's a good reason for the automatic stay to be lifted. You can go file in state court. The only reason I included this slide is that it's not an absolute. The bankruptcy court could still keep the case. It's just very rare, and it would be a very unusual set of circumstances for the eviction to happen in the bankruptcy court.
We had a follow-up question from Anonymous. Was asking, does this only apply to safety risks, or would it include non-payment of rent evictions as well?
Yeah, so that's a really interesting question. And again, a really good segue into the next topic. It probably would not include non-payment of rent. Because there are special protections about when you have to pay rent in bankruptcy. And so it's kind of before or after. There's a little bit of breathing room that's built into bankruptcy for rent payments. But then after that breathing room's over, then you got to pay rent. And so it could be a reason to seek relief from stay and proceed with an eviction. But it's more likely the bankruptcy court for non-payment issues would try to retain that issue and try to work it out in the bankruptcy. That's probably the more likely path forward. And so we can, unless Rachel, there's other questions, I can go into kind of when you have to pay rent and under what circumstances, and then kind of deal with that issue a little bit more.
No, that's it. Thank you.
Great. Okay. So as kind of like a big picture legal concept, most law that you're ever going to encounter out there respects parties' contracts. You know, if two people or who are competent agree to do something, courts and the law generally are going to protect that arrangement. There's a very strong protection of contract rights in state law and in federal law. And that is actually protected in the United States Constitution too. There's a contracts clause, not often observed or cited, that basically says states are not allowed to impair the obligations of contracts. But it says states. And so the notable exception to this is bankruptcy and federal bankruptcy law. Federal bankruptcy law gives some very limited exceptions to contract principles. And so we'll go over that and some of those exceptions because they're relevant to landlords and tenants. And I provided on the screen the special statute that gives all the different scenarios for when a contract can be modified or impaired or broken with limited consequences in a bankruptcy. So there are kind of three different ways that the debtor in a bankruptcy can treat a contract that it has that it had before the bankruptcy got filed. One way is to assume that contract, and assume is a bankruptcy term. All it really means is that you want to keep it. You want to keep that contract after the bankruptcy is over. If you assume the contract, you have to cure the contract. And so in the context of a tenant, let's say the tenant was behind 2 months of rent before they filed for bankruptcy. There's no eviction filed. they don't have to pay that rent right away. But by the end of the bankruptcy case, they have to decide to assume the contract and then pay that pass-through rent. Curing the paying the pass-through rent is what we call curing. Can also include non-monetary kinds of breaches. Those are less common, but those can also be cured. They can also be fixed. And all of those kind of defaults, all of those breaches, non-payment issues, they would have to be fixed before the end of the bankruptcy case, for the tenant to continue on under that lease. The next option is to reject a lease. And again, this is a bankruptcy term of art. It doesn't really mean what intuitively you think it means. All a rejection is a breach of the lease. The tenant says, I don't want this contract anymore, or I can't pay the amounts that are owed. So I'm gonna walk away from this contract under bankruptcy law. And so what that does is it just treats that rejection, that walking away, as a breach of contract that happened in pretend. This is all pretend bankruptcy world. We pretend that happened before the bankruptcy case got filed, even though it happens during the bankruptcy case. We just pretend that rejection occurred the day before the bankruptcy was filed. And the only recourse the other party, the landlord, has is to file a claim like any other person who was owed money before the bankruptcy case. There's no special protections for the person, the landlord, if the tenant walks away from the lease. But what's important about a rejection, so let's say a tenant rejects a contract, they walk away from the contract, but they don't move out. It's not like they don't have to still follow the lease, right? They're in breach of the lease, which means that they may owe money, they may owe whatever damages are under the lease, but it doesn't mean that they don't have to follow the other obligations until they've actually moved out and completely walked away from it. So there's a little bit of a balance in that rejection world. And we can come back to that concept. I know it's not super clear. It's tough. It's a very tough concept for bankruptcy practitioners too. People get it wrong all the time as a concept because it's bizarre. It doesn't work like any other breach of contract in the normal world. So we can spend more time in questions on that if you have questions. Something else that's really important about a rejection is that a landlord doesn't get the full amount that's owed under the lease as damages. The bankruptcy code puts a cap on damages that a landlord's allowed to get under a rejection. And this is a really powerful tool in the bankruptcy. So I know most tenants don't have leases that extend for more than a year, but if you did, the bankruptcy code basically caps the landlord's damages at 1 year's worth of rent. And so if you had a 3-year lease, you could reject that and only have to pay your landlord 1 year, which is a really powerful tool in the bankruptcy code. The last kind of tool for a debtor, and this really applies probably more if the landlord filed for bankruptcy, is to assign a lease. And so what this means is the tenant or the landlord, whoever wants to assign the lease, can sell its rights under the lease to somebody else. And they can do that regardless of whether or not the lease says you're not allowed to assign. The bankruptcy code trumps any provisions of a contract that says you're not allowed to assign this. And so anybody, the tenant or the landlord, can assign their obligations to somebody else as part of the bankruptcy process. Now, when they do that, they have to cure. So they have to go through the process. They'd have to go through assuming the lease. They can't assign it and then not pay the rent that's due under it. They have to pay the rent, and then they can sell their rights under that lease to somebody else in order to, to help fund the bankruptcy process is usually what happens. And so those are kind of the special powers the bankruptcy code gives to landlords and tenants in the landlord-tenant relationship process under a lease. The next slide we'll talk about are specific protections for a tenant that don't necessarily apply to a landlord and under this scenario. And so these protections that we'll talk about next really apply if a landlord has filed for bankruptcy, and let's say the landlord wants to sell the building. And when they sell the building, the person buying it doesn't want all of these tenants. They're not paying enough rent. Let's say that the person buying says, these tenants don't pay enough rent. I want you, landlord, to get rid of all those leases. The bankruptcy code lets that happen. And generally that seems kind of unfair. So the landlord can breach all of those leases, and they're allowed to breach those leases. But there's also some protections for tenants when that happens, and we'll go through those. So the number one protection that a tenant gets is that even though the landlord sold the building and rejected the lease, the tenant gets to stay in possession of their apartment or their house or whatever for the entire term of the lease and any renewals that are authorized as of a right? So the tenant has a right to renew. The tenant can stay the whole time. And so just because the landlord's rejected the lease and sold it to somebody else, the tenant does not have to move out in that situation. The piece that is a little bit problematic, though, in that scenario is that the landlord doesn't necessarily need to live up to all of its other obligations under the lease. This probably doesn't include health and safety obligations. I wasn't able to find a lot of case law on that, but I think, keeping the apartment up to health and safety codes would still apply. But there may be some other financial obligations the landlord has to a tenant under the lease that they may not have to abide by. And so the tenant can offset rent to meet those obligations. So if the landlord files bankruptcy, says, I know that I told you that you would have access to a pool, a common maintenance, a common area like a pool. We're broke. We're not going to provide pool service anymore. They're allowed to do that. There's nothing the tenant can do, but the tenant could offset rent based on the landlord's breach, based on that lack of service that was promised under the lease but not provided. But that's basically it. There's not a lot else the tenant can do against the landlord in that situation. And so those are kind of important exceptions for the tenant to understand. One other important thing to note too is that the landlord, rejects the lease and says, I don't want to perform under this anymore. The tenant could, and likely could, also walk away from the tenancy, even though there's 6 months left on the lease. They could say, oh, well, you breached, so am I, and they could walk away without consequence. That's a likely scenario. There's a few exceptions to it, but that's also kind of the recourse a tenant has under the bankruptcy code.
Question is, how is it determined like how much that pool is worth? Is that something that is determined as part of the bankruptcy proceeding, or is that just something that the landlord and the tenant have to agree on, or the tenant gets to decide?
That's a great question. It likely is a something that the landlord and tenant would collaborate on. They would discuss it during the bankruptcy case. And if there's a dispute, if the tenant says that's worth $500 a month, and the landlord says no, it's worth $100 a month, you owe me another $400 in rent, the bankruptcy court would decide that issue. And they would decide that issue through a motion. And so it would be kind of an abbreviated proceeding. That's the other thing that bankruptcy court's a little different on. Every dispute in bankruptcy is not its own lawsuit. Most disputes in bankruptcies get resolved through motions. And so sometimes that means you only have 2 weeks to respond to a motion, and then the issue is decided. It's a big benefit. It makes bankruptcies an efficient way to deal with those kinds of disputes, but it also is a quick procedure. So I would imagine the tenant would, send an email to the landlord, say, I understand that you are rejecting my lease and not going to provide any of the services that you promised to provide. I'm going to offset my rent by this amount. If the landlord disagrees, they can take it up with the bankruptcy court. There may be a hearing, an evidentiary hearing where sides put on witnesses, but that would happen really fast. It happened within just a couple weeks.
And obviously, it sounds like the tenant is being notified that their lease is being. Do they use the term rejection like in that notice?
Yep.
That sounds exceptionally confusing.
That's right. That's right. Yeah, and so this is a little bit procedural, but it's important. That's a good point. To reject a lease or to assume a lease, it's what's called a contested matter. So it's a special kind of bankruptcy hearing that requires notice to whoever's affected by it. They can't just file something on the bankruptcy docket and not tell anybody. They have to provide notice. It's likely going to be by mail. And then in a rejection motion, in a motion that says I'm going to reject this lease, the tenant is going to be identified by name. Either the tenant is the only subject of the motion, or there could be a motion with up to like 100 different tenants on it, but they would be listed alphabetically in that list. And so that's how that process would work. You would get notice, but it wouldn't necessarily be the clearest thing in the whole world.
Gotcha. All right, good to know. Thank you.
Yeah. So there are also a few protections for landlords in the bankruptcy code. So in this scenario, a tenant has filed for bankruptcy. The tenant is the debtor. And the landlord has a few things they can do to protect their rights under the bankruptcy code. So the first kind of landlord protection is that the tenant has to decide to assume or reject the lease within 60 days of filing the bankruptcy. So they've got to make that decision within 60 days. And that's where we've come into the whole question about what happens if the tenant doesn't pay rent during the bankruptcy. There's a little bit of a window during the 60 days. Technically, they're supposed to be paying rent. The bankruptcy code doesn't exist to let people continue to compound their debt problems, right? The bankruptcy code is not okay with that. They want people paying their bills as they become due during the bankruptcy. But you kind of have a little bit of a 60-day window before the bankruptcy court's going to force the issue. If you don't pay during that 60 days, the court will make you pay before the end of the bankruptcy case. You're not going to get off scot-free on those 60 days, but you may get, just as a practical matter, not as a legal matter, you may get a little bit of leeway. in those 60 days before you make that decision to assume or reject. But that only applies in a Chapter 7 case. And so that's in that, remember, we talked about limited situation where the tenant doesn't have a lot of assets, isn't going to be able to pay money over time, and just is going to kind of make the decision to, if they have a second home or they have a 401k account or something like that, they may liquidate that, pay their creditors, and move on. So in that situation, it's a 60-day window. In all other situations, including a Chapter 13, so that's kind of the more common bankruptcy that most tenants will file as a Chapter 13. You have the whole bankruptcy process to assume or reject. Again, that does not mean you have the whole bankruptcy process to pay rent. And especially in a 13, the court is going to expect you to be paying rent as you go. And there would be a reason to get stay relief and file an eviction if you stopped paying rent, if the tenant stopped paying rent during the bankruptcy. But you don't have to decide whether or not you want to stay in that apartment or that house until the very end of the case, when what's called a plan gets filed. And that the plan is the comprehensive new contract between the debtor and all of its creditors. And the debtor says, here's how I'm going to get out of this. And assumption or rejection of the lease is usually going to be part of that plan. But that's the deadline. If they don't make the decision by that deadline, then the default is rejection. So the default is the tenant's going to move out of the residence. And then the other kind of recourse a landlord has is to file a claim. So landlords don't have any special rights against tenants. They've got to wait in line like everybody else does as a creditor. So if the tenant goes in to the bankruptcy and owes 2 months of rent, they don't want to stay in their apartment, they reject their lease, the landlord can file a claim. And if the tenant's going to pay their creditors 10% of the claims, that's the best they can do. All the landlord is able to get is 10% of what was owed to them, and they're never allowed to seek collection of that again. They're never allowed to sue on that again. That debt is over with once that 10% payment is made. And so it's a landlord gets some protection, right? They can collect a little bit, but it's only as much as everybody else who's part of the bankruptcy gets to collect. And so our last topic today is security deposits. And this one's a little bit complicated. Rachel and I were talking a little bit beforehand. I don't know if the answer is super clear cut, especially in Minnesota, about what happens to a tenant's security deposit if their landlord files for bankruptcy. It's pretty clear to me that if a tenant files for bankruptcy, right, it has all the same rights that it would had the bankruptcy not been filed. Like, pretend there's not a bankruptcy to the security deposit. That situation applies 100% the same without the bankruptcy. Where it's unique is if the landlord files for bankruptcy. What happens to that security deposit? And we can talk through that situation a little bit. So the bankruptcy code defines what a debtor owns under a statute, and there's a statutory definition of what the landlord owns if it files for bankruptcy. It owns everything that it holds legal title to, so that makes sense, right? Everything with its name on it. But it also has to hold what's called equitable title. And this is a weird legal concept. I don't always still understand it fully, but basically that means there's some other kind of interest. And the classic example of this is a trust. So if someone's holding your property in trust, they hold legal title. Their name is on it, but it's held for your benefit. And so you have an equitable interest, and you're the equitable owner of that property. And so in that situation, if a landlord holds legal title to something, but not equitable title, it's not part of their bankruptcy. They don't get to sell it to pay creditors. They don't get to keep it at the end. It's just not theirs. It's not subject to the automatic stay in most situations. And so in theory, the tenant should be, if a landlord holds a security deposit and they only have legal title to the security deposit, the tenant should have equitable title to it. But that question, right, whether or not does the landlord hold both or does it only hold one, is an issue of state law. So the bankruptcy code doesn't answer that question. It provides the framework, but state law fills in the gaps. State law tells us whether or not the landlord holds legal and equitable title or just legal title. And so if the landlord just holds legal title, then the security deposit belongs to the tenant. The tenant can get it back under the same scenario it could under state law. But if the landlord owns legal and equitable title, then the tenant's only option is to file a claim and claim an interest in that deposit, but then it's going to have to sit in line with all of the landlord's other creditors. And that security deposit is going to go into the general pool of money. And, you know, if the landlord's paying 50 cents for every dollar that it owes, then that tenant's only getting half of its security deposit back. And so it really matters. It really matters whether or not state law defines the legal and equitable title to a security deposit. Minnesota statute, interestingly enough, is not the best. There are other states that have better statutes. And Rachel and I will talk about that in just a second. What Minnesota says is that the security deposit shall be held by the landlord for the tenant. That to me sounds a lot like a trust. That's whenever you make a trust, that's one of the magic words that lawyers use, right? This is held by me for you. That sounds like a trust. But Minnesota statute also says that the deposit is not considered to be held in a fiduciary capacity. And that's just legal jargon for not like a trustee. And so it says both things, in my opinion. It says that it's held as, you know, for someone else's benefit, but not as a fiduciary. And I didn't find any case law that kind of dealt with Minnesota law on this specific issue. And so I'm very interested to see if anybody else has dealt with this. But I think the answer is it depends. And I think, Rachel, you may have some interesting opinions too about how you think Minnesota law and practice treats this, and maybe some examples in other states.
Well, I may have had to go rely on Homeline favorite foundation for legal interpretations. Former Homeline staff Paul Bernberg has done extensive research into this issue. And so we're able to pull up a couple of old Eighth Circuit cases, kind of touch on this a little bit, but the general consensus is kind of what you were talking about is that essentially, and I'm so excited to get to use this term, the landlord is a bailee,
Great.
which I've never used that term since law school. So, but it's the tenant's money. It's bailed to the landlord. So essentially the tenant gets access to that. I remember we were talking about this before we started. Other states that do this sort of thing, like other states have like specialized accounts that landlords and tenants have to create or open to be able to, deposit the money in that, and then only it's only accessible by one of the parties, but they're both, considered owners of the account. It's with complicated. I know like New Jersey does that sort of thing. It sounds like Georgia does that sort of thing. So, but you know, eh, I think in practice, I agree with you that it's not the landlord's money because they're holding it is, I mean, essentially in trust for the tenant pending some uh now my question for you actually is that, like, say that, the tenancy doesn't end and or throughout this whole thing, but the landlord does have some claim for damages that are above and beyond normal wear and tear. Then they get to take that portion of the money,
That's right.
right? And then all of a sudden it does become part of their um
Exactly.
mhm,
Yep, that's exactly right. And so if they would be entitled to it under state law, then that becomes part of their bankruptcy.
so that gets fun and complicated.
Well,
uh
Rachel, thank you for clarifying that.
yeah.
That's really helpful. And that concept of bailee, I think, is exactly right. I think if Minnesota law would treat it as a bailee, I agree that it would be protected. The
Mhm.
tenant deposit would be protected.
Homeland Attorney Mike Vrah would like to know, does the landlord's obligation to pay interest on the security deposit, that 1% simple interest, is that factor into the equation in figuring out the answer at all for that?
Yeah,
Obligation basically to the tenant if they file bankruptcy as well?
yeah. I actually, in my opinion, that cuts against it because in that instance, it seems more like a debt. Um, I mean, there are instances where trusts are required to keep it in an interest-bearing account, right? But that's not really what the statute says. The statute just says you got to pay interest, right? It's up to
Mhm.
the landlord whether or not they put it into an interest-bearing account. And so if I'm saying basically I owe you a debt, I'm going to pay interest on it, that to me is much more like a creditor debtor relationship than
Mhm.
a trustee beneficiary relationship.
Would um, just the 1% interest be the debt, or would it be the whole thing?
Yeah, it would be the whole security deposit would be the debt, and then the
Mhm.
interest would be evidencing that it's like it's a recurring obligation, right? It's a debt owed, right? The
Mhm.
deposit is really a debt because it's
Yeah.
incurring interest, paying it back.
Mhm.
If you don't pay something back right away, you usually pay interest on it.
So anyway, I think the bottom line is that Minnesota law is unclear.
Yeah, I think I agree though. I think with Homeline's interpretation, I think there's a strong, very strong case that a tenant, if a landlord files for bankruptcy, the tenant should be asking for their security deposits back, and they should be taking special steps in the bankruptcy to protect their rights. And the critical thing that I'll reemphasize here is that you need to file a claim. And that's again another special bankruptcy term. A claim is a 2 or 3 page document. It's very simple. You put your name on it. You, in 5 words or less, describe why you have a claim against the debtor. You put the amount of it, and you sign, and then you submit that to the bankruptcy court, and that preserves your rights in the bankruptcy. If you don't do that, you can lose your rights. You can not have a claim, even though you're owed a security deposit, or the landlord breached your lease, or you have a slip and fall at your apartment and you're going to sue your landlord. If you don't file a claim, in most instances, at the end of the bankruptcy, you're not getting paid anything. And so you have to do that. It's really important.
Okay.
The way you'll, oh,
Mhm.
go ahead.
I was going to say, so if the, say, a tenant, landlord files for bankruptcy, tenant's still there, but, or they're moving out at roughly the same time, and they fail to fill out that claim for the security deposit, they can't go turn back around and file a conciliation court after the next month to get their deposit returned.
That's right. That's
Okay.
right. At the end of the bankruptcy case, the all the landlord's debt, all of its obligations are going to be discharged. And that's probably going to be one that's discharged. It's going to go away forever. And so you got to file a claim to preserve that right. It's really important. Yeah. And you'll know, you'll get notice of the bankruptcy. It's required. The landlord's required to submit a list to the court of everybody it owes money to, everyone it potentially could owe money to. And you'll get a couple-page document. And what it'll do is it'll provide you notice of what's called the meeting of creditors. You don't have to go to that meeting, but that'll have a deadline on it. That notice of the bankruptcy will say claims are due by a certain date. And you should put that in your calendar. You should mark it, because if you miss that date, you're out of luck. It's usually 30 to 60 days after the bankruptcy is filed that you have to get your claim in.
Okay. How about vice versa? How about it's the tenant who's declared bankruptcy, but like they have a security deposit that's being held by the landlord? Does the bankruptcy court get to essentially demand those funds from the landlord, or and the landlord would have to make their own claim for any like potential damages that they would take out of that security deposit for, repairs?
Yeah, so that's a really good question. And this is another situation where it's a little unfair. So so let's say the tenant decides to move out during the bankruptcy. They provide notice to their landlord that they're going to move out. They reject the lease. The landlord, especially if they were able to do this under state law, which I think they probably are, would be able to offset against the security deposit. And so that's a term that basically means, if I have possession of your property and you also owe me money, I can just keep that property to reduce the amount of money you owe me. That's called an offset.
Mhm.
And that's allowed in bankruptcy. And so that's where it's a little unfair. So if the tenant files for bankruptcy, the landlord gets to keep that money. And so, but right, it all depends on what the security deposit law says. So if under security deposit law, the landlord would not be able to offset, then they've got to give the security deposit back. But if they are allowed to offset under state law, then they can keep it.
Yeah, 178 does allow for that sort of stuff, so that would make sense then. So even if a tenant, like at the end of the day, was only going to be paying 10%, like you were saying earlier, on all their debts, the landlord could still keep all of that security deposit as an offset.
That's right.
All right, good to know. All right.
That is, those are our topics. I'm very happy to spend the rest of the time chatting about anything that's on somebody's mind, especially because we went over a lot of concepts that are very legal, and I'm happy to try to explain things a little bit better if anybody has questions.
Awesome. Well, thank you so much. That was a lot of information, as you say, but it was super helpful, I think, for us to have a better understanding. One of the things that questions we're getting here is again, from Mike, and this is really, I think, helpful for us, especially for maybe for those who are also, I'm just going to share my screen again, sorry. Can you just talk kind of generally about the practical impact on a tenant's credit for declaring bankruptcy. We tend to get a lot of tenants who are considering filing bankruptcy, but are trying to weigh the pros and cons. And if those have if that impact is different between like Chapter 7 and Chapter 13.
Yeah, so generally, the decision to file bankruptcy in what chapter is extremely individual. So it really depends on your financial situation, what assets you have, what what kind of money you owe to people. Different kinds of debts are treated differently under the bankruptcy code. So like the notorious one is student loans, right? If the reason why you're filing for bankruptcy is you've got too many student loans, you're probably out of luck, because bankruptcy code doesn't let you get rid of student loans. If it's credit card debt, that's better, right? That's something you can deal with. But if it's like your mortgage, right? If you owe money to your bank under your mortgage, and you just can't pay it, you don't have a lot of protections under the bankruptcy code. And so those kinds of scenarios, it's really important to talk to someone who specializes in individual bankruptcies. So in Chapter 7s and Chapter 13s, oftentimes those folks will do an assessment with you. They'll sit down and they'll do a consultation. You'll bring them your taxes, you'll bring them, some bills that you have, and they'll kind of advise you on which one to do. Now, whether or not you file a 7 or a 13 is actually really not your choice. The bankruptcy code has what's called a means test. Again, we like to use weird words. And means like above your means, right? People say that, right? Above what you have, your ability to pay. So a means test basically looks at all your assets, all the things you own, and all the liabilities, all the things you owe to other people, and does a calculation and decides whether or not you qualify as a Chapter 7 or a Chapter 13, or Chapter 11. That's actually the other option. So if you fall on one side of the means test, you are a Chapter 7. If you fit the means test, you're a 13. And if you exceed the means test, you're an 11. If you have a lot more income or a lot more debt than what's allowed into the means test, you're going to have to file a Chapter 11 case. And so the bankruptcy code basically tells you what you have to file.
Gotcha. And that's not something that like an individual could just go file like you would like a conciliation court or an eviction case, right? Theoretically, you'd need an attorney to help you do that, right?
So technically you can file on your own, but and there are pro bono attorneys who provide some advice to folks filing for bankruptcy. It's very complicated. I've only ever done corporate filings, so I filed corporations for bankruptcies, but the forms are very similar and they're very extensive. They're very easy to mess up. I mess them up all the time, and I have to fix them. There's a lot of steps that you have to take. There's credit counseling you have to do. There's just a lot of preliminary things that go into filing for bankruptcy, and a professional is going to know what you have to do and all the pitfalls. You don't absolutely have to. Lots of people just fill out the bare minimum to get the relief. But there is a downside to that too. So if you file a bankruptcy case and it doesn't end the way the bankruptcy code anticipates it ending, you can be barred from filing a bankruptcy case for a certain amount of time. Or you can file, but you don't get the protections of the automatic stay. So it's those provisions are there to keep people from constantly filing for bankruptcy, to prevent like their house from getting foreclosed when they don't have any hope of actually using the bankruptcy to move forward, right? Bankruptcy is not there as a litigation tactic. It's not there to, give you a special advantage. It's there to fulfill its purpose, which is to get the case resolved equitably and provide a fresh start for people.
Gotcha. Thank you for that. Well, we still have about 10 minutes left according to my clocks. So if you've got questions, whether for Drew or for me, we've got a little bit of time to chat about that. I know I'm going to move the slide back to Drew's clearly taken maybe a year or two ago's picture.
That's right. Definitely pre-COVID.
Um, so all right. And yeah, again, we will be applying for CLE credits for this. We'll send out an email with the code after we get approved, which is really up to the CLE board. It's been taken a couple weeks from when we've requested it for us to actually get approval and code. So just, I guess, be aware of that. And yeah, if there are, again, questions, or if you are a tenant here in Minnesota and you've got like specific questions about your situation, feel free to give us a call or email us. We're happy to help out. So for Drew, I'm trying to piece together this. So when I guess the whole like landlord's filing
Sure.
impacts their tenants the same way, whether it's commercial or residential
Yep.
tenancies. But say there's also not much difference, honestly, of how it's treated if it's a commercial or residential tenant, right? Who is filing for bankruptcy in cases of like all the notices and things like that, right?
Yeah, so that is actually really interesting. So what I kind of went over today, the bankruptcy code does distinguish between residential tenants and non-residential tenants. And
Okay.
then there's actually a third category, which is shopping centers. So there's
Mm,
3 buckets. And there's different rules that apply for commercial tenancies and
okay.
for tenancies at shopping centers. Um,
Okay. So
but
what you were talking about today is specifically what the rules specifically say about residential tenants then?
Yep, that's
Okay.
exactly right. That's
Awesome.
exactly right. Yep.
Okay. That's super helpful to know. Okay.
Um, I'm also happy if folks have questions that they want to send to me by email. I'm happy to get emails.
Mhm.
It's just my name, Drew.Glasnovich at
Oop,
Stinson.com.
I will
I'm
drop
happy to,
that
yeah.
in the thing. Someone just popped in with a question. What does one do if a bankruptcy case has concluded, but a creditor is still trying to collect on the debt? Do you go back to bankruptcy court? Like, how do you stop that?
Yeah, that's exactly right. So yes, you go back to the bankruptcy court. Usually what happens is there's an order for discharge, which is the last thing that happens in an individual's bankruptcy, and that gets rid of all the debt. But that's also an injunction. And what an injunction means is it's a court order that tells people to stop doing something. And if you violate that injunction, you're in contempt of court. And the bankruptcy code actually gives special powers if you violate the discharge injunction. And so if um, a debt is discharged in the bankruptcy and it's not collectible anymore, and a creditor still tries to collect it, you can take them to bankruptcy court and seek a contempt order and get your attorney's fees, get whatever damage. If they repossessed your truck and they weren't supposed to repossess your truck, you get damages for that. It's a big deal. Your creditors should not be doing that. It's a little bit more complicated. For instance, if let's say you have a Chapter 13 plan, so you've promised creditors how you're going to pay them over time, and you can't fulfill that promise. You're kind of getting towards bankruptcy again. That creditor can come back to the bankruptcy court, but they've got to ask for relief from stay. They've got to go back and ask permission to do anything. If they don't, they're violating that plan, what they've agreed to in the plan, right? And it's the same deal. They can be held in contempt or held in violation of the automatic stay. Rachel, one thing I remember from the pre-submitted questions is about mobile
Yes,
homes.
that's right. Yes, thank you for that.
Yeah, I forgot to address that. So I looked at this a lot, and I think my answer, I think the question was, what happens if the debtor owns a mobile home and is a tenant at a mobile home park and owes lot rent?
Yeah. So specifically, it says, how does filing bankruptcy affect lot rent in a trailer park when tenant owns trailer but is behind on lot rent?
Yep. And so I think lot rent is still a lease for real property, right? Even though I understand that um, the law around mobile homes is a little bit different than a resident, a single family home. That home is real property, just like the ground is, right? But a mobile home is essentially a vehicle, right? It's a special kind of vehicle, but it still
Exactly.
sits on real property, and the lease is still for real property. And so I think these provisions still apply. Is the best I could gather in researching this. There was not a lot of case law on this that I could find, and there's not anything specific in the bankruptcy code that distinguishes renting, a plot of land to put your mobile home on, or renting a plot of land that has a house on it. I think those things apply the same. And so it would be just like if you owed money as a tenant in an apartment building. If you don't pay lot rent, you have a little bit of breathing room. You can decide whether or not you want to assume that rental agreement, or if you want to reject it. And if you reject it, then you got to move. And if you assume it, you've got to pay the money back.
Okay. Thank you for that.
Yep.
Yeah, the mobile home parks are a little bit of a complicated
Right.
situation because then there's other rules outside of bankruptcy, obviously, about how you then work with the actual property that you own and selling that and things like that. And yeah, and you covered, I think, very well the other pre-submitted question of if the tenant files for bankruptcy, does it affect the lease? Yes,
Yeah.
is the short answer to that. Um, well, brilliant. Thank you for remembering to answer those. Um, if there are no other questions, I think we've hit all the ones that were submitted in the Q&A, and for the pre-submitted ones, thank you again so much, Drew, for all
Sure.
of your time and your expertise and just trying to clarify this fairly complicated set of rules. It's really, really appreciated.
Sure.
I know it certainly is going to help us at Homeline here. Hopefully it's helped some other folks out there as well. And again, if you've got questions, feel free to reach out to Drew, or you can reach out to us here at Homeline, and we will be having another of these webinars next month. More info will come out shortly about that. So thank you all. And again, thanks, Drew. Have a great rest of your day now. Bye.